Article 3, 4, and 6 of the 2020 Rules of Procedure spoke about the competence of the African Commission to interpret the African Charter and respond to requests for advisory opinion, to interpret its own decision, and ensure efficient and technical organization and operation of the African Commission Secretariat. And I think most important, one of the important pushback is also the fact that the Commission retained the resolution on granting and maintaining observer status as its primary basis for granting observer status, as opposed to using the AU criteria that was prescribed in Decision 1015. And the 2020 Rules of Procedure also show another reaffirmation of the independence of the African Commission to conduct its own affair, in that it's now allowed the African Commission chairperson, in consultation, of course, with other commissioners, to decide the venue and schedule of sessions, as opposed to the old 2010 rules that in a way give substantive powers to the chairperson of the AU Commission as it relates to the sessions of the Commission. So now, what is the way forward? We can see that the decision has been given, the Commission has implemented some of this decision, the Commission has also pushed back. Now, I think what we can learn, what we have seen from the events of Decision 1015 is that the African human rights system is not perfect. Clearly, I don't think any system is perfect anywhere, but ours is definitely far from perfect. And first of all, it is our jobs as civil society organizations to keep improving the system. Clearly, we cannot throw the baby out with the bathwater. And looking at the significance of the relationship between the African Commission and civil society organizations to fulfill its mandate, I think it is important for us to continuously support the work of the African Commission. And the final thing that I would say is that I think it's also important for civil society organizations to try to enlighten AU member states about how they can, in a better way, approach and take steps to improve and strengthen the effectiveness of the UN treaty bodies. Because this has been done by the UN General Assembly, and in the course of doing that, the General Assembly has reaffirmed the importance of the independence and impartiality of members of the human rights treaty bodies, and also the importance of stakeholders of the treaty body as well as the Secretariat. So I think this is something that we need to make member states understand, that even though this and this is possible, but there's a limit to the extent to which you can push for some of this reform that you're pushing for.
So very well done, Foluso. Thank you so much. Very rich presentation. I really appreciated the fact that you were able to summarize really two of the most important outcomes of the decision. One, to improve on the face of it, the political correctness of the decision, the way it was presented, in terms of improving the cooperation between the African Commission on Human and People's Rights and different AU policy organs. But the second one, and more threatening, more concerning, really an attempt, decision rather, to curtail the independence of the Commission, to redefine its mandate and really its functions and operationalization. The other point I really about your presentation is the dilemma that you posited before us, the dilemma before the African Commission on Human and People's Rights, but also before before African civil society organizations. What do you do? How do you win the war while accepting to lose a fight, as you aptly put it? What kind of the types of tactical moves that the African Commission implemented? Where were we? Where were the African citizens during that fight? That's an interesting, I think, aspect to the discussion, to the debate, which I hope Commissioner Mute will also touch on. The way forward, first starting with an acknowledgement, we are not a perfect union, as other spaces like to put it. This is a journey in the making. And also the fact that it's important that ultimately we should always keep an eye on the ultimate prize, which is changing and influencing the behavior of AU member states. On that note, I am going to have the pleasure to invite Commissioner Mute to present his thoughts. After Commissioner Mute's presentation, I'll be moderating the Q&A between our panelists and the audience. So feel free to populate the chat with your questions and comments. Thank you. Commissioner Mute, over to you.
I'm in an unusual setting. I didn't have power this morning, so I've had to look for a place to speak to you from. So thank you so much. I want to speak to you under a theme. I decided I should craft a theme, obviously guided by the paper as presented. And so my theme is eschewing dogma, embracing pragmatism. So basically, whether the discussion might be about avoiding dogma and embracing and being pragmatic. So that's how I want to look at this. So as I said, I was asked to provide a perspective on implementation of AU Executive Decision 1015. Obviously, I come with certain advantages since I was a participant in some of the key events that happened in the material period when 1015 was issued, and also in terms of the Commission's response or responses to some of what 1015 said. Now, I think the premise of discourse in recent years is that that decision, 1015, of course quite infamous, may have aggravated the erosion of the Commission's independence. So that seems to be the premise, and that seems to be the basis upon which many organizations, many individuals have done a lot of work in the last couple of years. I think the question one needs to ask, the question we need to respond to is this one. If Decision 1015 had not been adopted, how differently would the Commission have addressed the issues which are material to this discussion? So in other words, to what extent did the decision simply vocalize actions which the Commission anyway would have had to do, would have undertaken in the ordinary course of its work? I think, that's a question which really we need to keep in mind. But before then I focus on it, there's some context which I think I need to set. I think there's a conceptual, perhaps normative misapprehension, which is at the heart of this particular discourse. So in fact, not so much, not particularly in the way the paper is presented, particularly having listened to Foluso and his summary, but I think more in the essence or the approaches which have been taken, or the rhetoric which has been taken in the last couple of years. I think one of the contentions now, which is specific to the paper, I think, is that the African Charter on Human and People's Rights, the drafters of the African Charter, never intended to be fully accountable to the Commission. So the paper, I think, as was explained, contrasts the institutional framing of the Commission under the Charter, and I think it makes that contrast possibly in favor of the Human Rights Committee as established in the International Covenant on Civil and Political Rights. Now, and I think the conclusion seems, if I understand it correctly, that the AU Assembly's insistence, for example, on the regularization of the Commission as an organ of the Union, should be understood as prejudicial to it, relative, let's say, as compared again with the Human Rights Committee, which then in that sense is an independent human rights body. Now, my view is that this conclusion might be overly stark. I think we need to make sure we do not fail to take account of context and nuance. So, there are, very real dynamics which Africa confronts, which Africa, in fact, had to confront when the charter was being drafted. Now, if I may make a quick illustration, and moderator, I decided in my mind that what I say earlier is more important than what I say later. So if I don't reach the end of my presentation before my time, that's not too bad. Now, what confronted the fathers of the charter, in my view? So when you're thinking about people like President Leopold Senghor or Sadaura Jawara or people like Edem Kojo, what confronted the fathers of the charter and also the technical team, the drafters, was how to persuade the continent to adopt a technically competent human rights instrument that would make real positive difference in the lives of Africans. Now, if you look at what the promoters of the charter intended to do, if you recall that time, they were dealing with very interesting times. They were dealing with states which were in blocks. So you had a few states which were quite liberal, rule of law, etc., etc. You had many, many states which purported to be socialist, but which essentially were one-party states. And then you had extremists, a couple of extremist Marxist-Leninist states, okay? And in Nairobi, at the summit which was adopting the charter, the kind of demands which states were still making were actually, so diverse. States were making so many diverse demands. They are saying, look at this commission which you're setting up. The mandate which you're proposing under Article 45 of that commission, of that charter, is undue interference in our internal affairs. That's what they were saying. They were saying, look at the powers of the proposed commission. They go beyond the objectives of a human rights charter. And there are so many more things which they were saying. What I would suggest we all do, ladies and gentlemen, is that you need to read that excellent history of the charter by Justice Jallow. It's excellent and really it sets excellent context for some of this. So for me, it is a great wonder that actually Africa in the end, or the African Charter in its current form, was actually adopted at all. In fact, I doubt that presently we'd actually be able as a continent to adopt such a profound charter. So my argument then is that when we have this discussion on independence, I think it needs to be far more nuanced. So you can speak about substantive independence, ICCPR type substantive independence, but as Foluso correctly, I think, points out, really the focus needs to be on functional independence. So then the question which I ask is independence, but what independence? So away from the emotion which is evoked by Decision 1015, what scholars, what practitioners must do is explain the actual import, the actual purport of independence. What exactly does it mean? And then what exactly is it that the commission is doing, has done, could have been doing better? So I think independence has to be understood as bearing, those two limbs which I just mentioned. Substantive independence, essentially complete, legally established independence, but then functional independence, which really I think is what we should be discussing in this discourse. Of course, I am not saying that the substantive independence of the commission is not important. And clearly, for example, when you look at our resolution 402, so resolution 402 of the commission was about the inherence of the interpretive mandate across our Article 45 functions. So here actually about the law. We were speaking about the law, we were very clear about that. And so I'm not belittling the importance of substantive independence, but I'm saying it needs to be understood contextually. So then my next question, if I try to move quickly, is, so when we speak about functional independence, then there are a number of things which are at the heart of functional independence. I think the danger in the last couple of years is that because of what 1015 said, we might have been so focused on trying to insist on the substantive or independence of the commission that we actually lose a sight of the big picture. And what is the big picture? The big picture, it is not about dogma. It is about whether the commission is able to continue doing its actual work. That the Commission should not fall into the trap of conceding its practice of functional independence to the rhetoric of the AU's political organs. I think that's what we need to be careful about. So what does all that mean at a practical level? You're going to ask me several things. One, I can assure you, there are certain things which remain sacrosanct. So for example, the protective mandate of the Commission is sacred. So when we speak about communications, those ones would not be touched by anyone, not states, not anybody. And so even in the instance of, I'll give an example of communication 426 against Rwanda, which the Executive Council, I think without any basis in my view, returned to the Commission. Actually, what you will notice is that communication 426 eventually again was determined by the Commission properly, and actually it sets or it affirms excellent jurisprudence in that area. Of course, you could argue that in the meantime, the claimants or the applicants have been waiting, but the point is that was done the right way. Of course, you could point to me correctly and say, but what did you do with Carl? So Carl, in my view, that is a discussion which will have to happen another day when Marie persuades me that we should have that sort of discussion. But the bottom line there is we are not speaking protection. So protection is sacrosanct in my view. Carl is extremely problematic. For me, extremely sad that the Commission did what it had to do. But again, it goes back to that distinction which I was making earlier, the dogma versus pragmatic distinction and the sorts of decisions which the Commission has to take under certain circumstances. Now, I should quickly speak about Article 59. Now, our experience as the Commission's Bureau, when I was part of the Bureau, was that most of the demands that the Executive Council might make would fade away in the face of the letter of statute. So actually, that usually is what would happen. But when you look at Article 59, then the question becomes, what's the relationship between the activity reports and then what the Executive Council says or does not say? And my sense there is that actually we already have a framework, and that framework essentially says when a report is in play, the report may not be changed in substance, in its substance. Of course, errors on the face of the record may be corrected. So if I call Eswatini the Republic of Eswatini, then clearly that is something which needs to be corrected because it's wrong. That's an error. And then the other agreement is that where states then are unhappy with substance, they are allowed to annex. They are allowed to include annexures at the end of the report of the Commission. Now, am I saying that there are no instances where the Executive Council has done the wrong thing? No. Far too often that happens. Should we be surprised that the Executive Council or the PRC sometimes attempts to do the wrong thing? No. Actually, in fact, I'll be surprised if they always did the right thing. Because you see, for me, the whole point of human rights is that this contested space, it's about claims, it's about claimants. You need a commission which is out there, not in an ivory tower or in a glass tower. You need a commission which is out there, which actually engages on the substance. Now, the other thing which I then need to quickly say, again in agreement with Foluso, is to go back to my original question, are there things which we have done, which we would not have done? Already, we were preparing our rules of procedure before 1015. When you look now at our rules of procedure, we have even clarified, I think in Rule 3, that yes, we are an organ of the union, and in fact, that's something we wanted. So you see, it's not as if we are saying we want to go away from it, because we think when you are an organ, then actually you're not a department. Remember, contradistinction of organ with, in terms of nomenclature of the AU, then you'd be speaking about a department where they hire even the drivers for you, which really is quite problematic. So my sense is that look at Article Rule 3, look at Rule 11, I think on Code of Conduct, look at the rules around NGOs, I think that is our response to 1015. And I do not think that our functional independence, we have allowed our functional independence to be undermined. As I said before, how we have responded to the very peculiar situation of Carl is very problematic. Thank you very much.
Thank you, Commissioner, for a very rich and substantive presentation. You've, it'll be very difficult to summarize it within the 1 minute that I'm giving myself. But suffice to note that I think you made a brilliant contrast. You contrasted brilliantly. I think the whole notion of substantive independence and functional independence. You've presented, I think, the dilemma, or rather the contestation that erupted after Executive Council Decision 1015 was adopted within a larger historical and political context. You mentioned the different imports of issues that have been brought, analyzed, and litigated by the Commission. You mentioned Resolution 402, which talks to the inherent interpretative mandate of the Commission. You mentioned the fact that it's important not to lose sight of the big picture. We contrasted dogma and pragmatism in how we need to support and strengthen and build and engage with the African Commission on Human and People's Rights. On this note, I do have a couple of questions, but I think there are other questions on the chat. To both speakers, should we be looking at substantive versus functional independence, or how the two need to be mutually reinforcing? The independence of the Commission should not mean that it divorces itself from the mother entity, the African Union. This notion could introduce tensions between the two. The question comes from John Njoka, and I'm going to start with Commissioner Mute, if you could respond to that question, if you heard it. And after that, I will invite Foluso. Let me give you a second question from John to Foluso. Foluso, you have a second question. Foluso, thanks for your presentation, which is very balanced. How do you measure perfection of a human rights system? What lessons can the African Union learn from UN systems on this notion of system performance? Olufunke asks, can you please elaborate on the matter of the Coalition of African Lesbians? What are the issues? How did the African Union Commission handle the matter? What are the implications? And the question is from Mojubaolu Olufunke Okomeki, who is a professor of political science, African and Women's Studies, Brooklyn College, City University of New York. And thank you, Olufunke, and hopefully we'll have the appropriate response to your question. Commissioner Mute, the floor is yours.
Actually, in my written notes, I had made the point of stating that substantive independence and functional independence are not mutually exclusive. So even as you try to distinguish or to explain between the two, clearly we are not speaking about things which are completely different than each other. So clearly we need to be careful about that. There are certain things which are established in the charter in terms of the functions of the Commission, and they're extremely important. And that is why you notice 1015 was couched in a quite interesting way in respect of the interpretive mandate of the Commission. 1015 there was calling on states to do something, to look at that mandate. So basically, it's as if 1015 was suggesting to states, perhaps you should consider amending the charter, okay? And that's why the Commission really quite clearly had to explain using 402 the value of the work which it does, and also the substance of that. So let's not seem as if we are saying that they are completely different than each other. And I agree, therefore, it's about holistic approach. It's about, therefore, making sure that we do not become rigid and inflexible in the way we approach or in the way we try to present and articulate some of these issues. Now, a couple of things I wish to say about CAL. Obviously, 2015, CAL is given NGO observer status. Those of you who may have been part of that, or who may recall, you recall that even the NGO observer status itself, the accreditation was contested on the floor of which is very unusual. The decision by Executive Council to withdraw was made again in 2015. Then a couple of NGOs went to the African Court to seek interpretation of the Executive Council decision. Then in the meantime, therefore, the Commission essentially told the Executive Council that the matter was sub judice, so it could not move on it. Then in 2018 or thereabouts, 2017, when the court determined it did not have jurisdiction to determine the matter, I usually think that they conveniently walked away from it. But anyway, when the court decided it did not have jurisdiction to determine the matter, the Commission, if you look at one of its activity reports, did go back to the African Union, to the policy organs, and actually did explain substantively why the Commission knew it was right in its accrediting CAL as an NGO. So actually you'll find a couple of paragraphs in one of the activity reports detailing that. Now, then what happened was the Executive Council insisted that actually this should be, not the decision should be withdrawn. And I think at some point they even gave a deadline by when that would need to be done. I think that's what I can say for now, because really the rest, in terms of what happened, I think now that's an internal. I don't know, because I don't know the current state of things in terms of what exactly the Commission is or is not doing about it. But clearly, the Commission in the end took a decision. Possibly, I don't know, perhaps if they looked, or if we looked at the deadline and if we tried to figure what the implications of that, of passing that deadline were. So clearly, yes, there are issues there. As I said already, it's not as if I'm saying there will not be tension, and there will usually be give and take. Unfortunately, in the course of that give and take, then people's rights get violated. And perhaps this might be one instance when that happened.
Thank you, Commissioner. Foluso?
I think on the issue of CAL, I would say I don't think I can answer it better than what Commissioner Muthia has said. And I also see that we are pressed for time. So with respect to the second question on substantive and functional independence, I also share the same view with Commissioner Muthia, and I wouldn't be addressing that in the interest of time. So I would just talk about the need, how do you measure perfection of a human rights system, and the lessons that the EU can learn from the UN system, or the notion of system performance. First of all, I would say I don't think there is a way to measure a perfection of human rights system. And I don't also think personally that there can ever be a perfect human rights system for two reasons. One, human rights issues are generally social issues. And these issues are not issues that are predictable, and they are things that have to be responded to within the context in which they occur. I think Commissioner Muthia made reference to the context in which the African Charter was drafted. And for example, you look at the COVID-19 pandemic. I mean, before 2020, nobody was talking about the human rights effect of pandemic. But now there's a COVID-19 pandemic, then we realize, okay, this is a social problem. There are human rights issues. So there can never be that system that will effectively take care of all of these issues. Then the second thing is, I think we also tend to forget that international human rights law is not strictly legal, which still feed back to my first point. It is within the realm of human rights law and international relations and diplomacy. Because when you look at it, the primary entity that is required to implement international human rights law, they are states. And usually states are very reluctant to concede their sovereignty. So there is always that need to keep engaging with the system. So that's why I think there is no perfect system. There can never be a perfect system. And to just finish on that, I would say even the UN system has been described by scholars as early as in the early 2000s as a system in crisis. So it's not as if I'm saying or we're saying that the UN treaty system in itself is perfect. It's just that what I think, which feeds back to the second question now, the lesson that I think the EU can learn from the UN level system is that in a way, even though the UN General Assembly has been taking measures to improve the treaty system, it has stayed clear of the independence, maybe the functional independence now, of the treaty body members. So in a way, the improvement is not being done in a way that encroaches on the freedom or the independence of the treaty system. So that's what I think the UN and the AU can learn from the UN system, because like I said, there will never be a perfect system. There will be the need to constantly engage with the system. Thank you.
And I believe that the audience has really appreciated your responses, which is great. I'm supposed to wrap up and provide concluding remarks. But instead of doing that, I'd rather flip it around and have one final question to both of you. And the question is very simple. What now? We have Executive Council Decision 1015 that's somehow, and it's fair to say that there's a section of a solid number of civil society organizations that have really struggled to move beyond the debate and the controversy around that decision. Look, for one, the Coalition for the Independence of the African Commission was triggered by that decision. And there are other spaces where organizations have really come together, debated, brainstormed, and came up, or at least attempted to come up with some sort of strategic engagements in order to push back. So the Commission pushed back. Civil society organizations and NGOs have also tried to push back. On behalf of the audience, we would like to get your final thoughts on what should we focus on right now. How do we move beyond that? Commissioner Mute, you've explained we need to go beyond the actual emotions that specific acts, specific decisions will create. Foluso, you've mentioned the fact that it's important to have a critical analysis of the decision and its impact. Now, let's go beyond that. What would you say? And after your response, we will close the discussion.
A couple of things. It seems to me that Decision 1015 obviously happened in a particular context, and so we then need to make sure we are focusing more on specifics rather than generalities. And the sorts of questions which come to mind when you, for example, think about the operational autonomy of the Commission, then obviously it's those difficult questions which actually civil society has been quite good at asking. So you're asking the substantive questions about whether or the extent to which we are delivering our mandates effectively, and perhaps a little more on time. So, one then would be having a discussion around communications. One would be having a discussion around how quickly the turnaround on concluding observations is happening, etc. So specifics rather than generalities. But then second, when I was looking at functional independence, I had identified a number of indicators, which I could not speak about obviously for time. But one of them is about institutional and organizational capacity. So again, in terms of the Commission's infrastructure, what energies as civil society are we spending in terms actually of making sure the commission has better resourcing, has better staffing. One of the questions I would really ask now around membership of the commission, which is a different matter in terms of our indicator. How many of you as civil society, for example, know that just now closing is or are advertisements for members of the commission? The moment we speak about functional independence, you also do need technically competent people in the commission, people who also are of goodwill. How do we get those without your participation? Because I've actually usually been extremely underwhelmed when I was in the bureau to go to Addis Ababa waiting for contested recruitment of new commissioners. And usually there'll just be one, not good enough. Now, finally, in my experience, members of the PRC, speaking about the PRC specifically, individual members of the PRC can be extremely problematic. In my experience, the chairs of the PRC or the Executive Council usually tend to be well advised on what the right thing to do is. My only experience, really, which was bad in the hands of a chair, was during the Nairobi retreat, when the commission was retreating with the PRC, and when I actually felt that the PRC, and particularly the leadership of the PRC, were actually forcing the commission into a corner. But otherwise, consciously, what I have found is that, of course, they have their dynamics, but you'll have experiences where you go into a summit, and the members are insisting on a particular line, and sometimes even the chair will rule and decide this cannot happen because this is supposed to happen. So therefore, also I would be encouraging civil society to try to figure how do we open, or have we opened channels of communication with them, because obviously they protect their interests and obviously they think union, but let's not be too cynical about these things. So I think that would be that would be what I would say. So please, let's move forward. Perhaps you will need to really figure whether highlighting independence as a key thing without clear deliverables is a way to go, or whether you can recast things, but actually you'll still be doing the same thing, but now at a substantive level, engaging on specific issues rather than on the generalities. Thank you very much.
Excellent. Thank you. Thank you, Commissioner Foluso. Can you do it in 1 minute?
Yeah, I will, because I think Commissioner Muthia has said all that has to be said. But I think one thing that I would just add is that, there are times that people do things and we don't anticipate the consequences of what we are doing. So I would say, you mentioned the coalition, and I would say the coalition and every other thing, every other gathering of NGOs is actually a positive unintended impact of Decision 1015. And I think that is something we should focus on and build on, because if there was no Decision 1015, like you rightly said, we probably wouldn't have these coalitions. And so in a way, it has also impacted positively on civil society, and we can build on that to improve our engagement with the African Commission, and aligning myself with every other thing that Commissioner Muthia said. Thank you.
Thank you. Thank you very much. Thank you to my co-panelist, Commissioner Mute, Foluso Adegalu, for brilliant discussion.
Thank you.
Bye, everyone.
Bye.